Although the United States Constitution grants certain rights to citizens, over the years, laws and court decisions have limited their application in the workplace. The right to privacy is defined in legal terms as an individual's freedom from unauthorized and unreasonable intrusion into personal affairs. The Privacy Act of 1974 was enacted to protect individual privacy rights in the United States. It includes provisions affecting HR record-keeping systems. This law applies only to federal agencies and organizations supplying services to the federal government. However, similar laws in some states with somewhat broader scopes have also been passed. For the most part, state rather than federal law regulates private employers on this issue. Record-keeping and retention practices have been affected by a provision of the Americans with Disabilities Act known as the ADA, requiring that all medical-related information be maintained separately from all other confidential files. The Health Insurance Portability and Accountability Act, known as HIPAA, also includes regulations designed to protect the privacy of employee medical records. Both paper and electronic files must be safeguarded. As a result of all of the legal restrictions, many employers have established several separate files for each employee. It's important to establish access restrictions and security procedures for employee records to protect the privacy of employees and protect employers from potential liability for improper disclosure of personal information. Individuals' social security numbers, personal addresses, and other contact information should be protected. The Data Protection Act requires employers to keep personnel records up to date and keep only the details that are needed. The following guidelines are offered regarding employer access and storage of employee records. First, restrict access to records to a limited number of individuals. Use confidential passwords for accessing employee records about various HR databases. Set up separate files and restricted databases for particularly sensitive employee information. Purge employee records of outdated data, and release employee information only with employee consent. Personnel files and records are usually maintained for 3 years. However, different types of records should be maintained for shorter or longer periods of time based on various legal and regulatory standards. Another concern is how electronic records are maintained and secured, especially given advances in software, email, and mobile technology. Organizations should establish an electronic records policy to ensure legal compliance and avoid violating individuals' personal rights. Data privacy is becoming increasingly important with the growth of mobile technologies and the use of applications or apps that offer various functionality. A large number of applications collect information about users. It is vital to ensure that an organization's policies accurately and completely identify all data being collected so that users are aware of how their personal information is being handled.